Hello everyone, myself Dr. Rajashree Jawale, Assistant Professor, DG College of Commerce, Satara. Today we are going to discuss about remedies for breach of contract. So in the earlier lecture we have seen the basic concept regarding remedies for breach of contract. What is a contract? Section 2, subclause H of the Indian Contract Act 1872 simply defines a contract as an agreement which is enforceable by law. In other words, a contract is an agreement, the object of which is to create an obligation. So when an agreement enables a person to compel another to do something or abstain from doing something, it is called a contract. So contract means to do or not to do anything which is agreed upon or agreed under the contract or an agreement, and that agreement which is enforceable by law is only treated as contract. In today's lecture we are going to talk about what is a breach of contract, damages for the loss sustained under section 73, clause 1, clause 3. There are rules, 4 rules are there. A degree for specific performance. Suppose if there is breach of contract, then in that case party can go to the court of law and they can seek the remedy, or they can enforce or ask for specific performance. So when there is no standard for ascertaining actual damages, then specific performance may be there. There is very important case, that is Duke of Somerset versus Cookson. Then an injunction, and then when are perpetual injunction granted. So all these points we will be covering in the present lecture. So remedies for breach of contract. In this particular slide we can understand that when the parties are not agreed upon the terms and the condition, or suppose previously when they entered into a contract, at that time there was not any problem, and later on if there was dispute, or if there is dispute, or there is ambiguity in implementation of a contract or an agreement, so there may be a violation of duties or their liabilities. So in these cases there may be a breach of a contract. Party may fail to perform their duty in a particular manner according to the contract or the agreement. So in that case there are many reasons by which the contract may be breached. So in this lecture we are going to discuss about the various remedies which are available. So remedies for breach of contract. There are self-help remedies and judicial remedies. So here today we are going to discuss about judicial remedies. There are damages, that means the compensation. If there is breach of contract, damages may be granted or compensation may be given to the aggrieved party. Second is rescission, that is the cancellation of an agreement. If both the parties are agreed to cancel the contract, then in that case there may be a rescission of a contract, or a cancellation of a contract at the option of the parties. Then third is about specific performance. If the contract is break down by the party, either of the party, then they may decide what to do, how to discharge the contract. If the party are ready to perform their obligation or the duties or the terms and the conditions which are assigned under the contract, then in that case there may be a specific performance voluntarily. But if the parties fails to perform their duties and the obligation, or they fails to perform their duties according to the terms and the condition, or if they are not acting in accordance with the object and the subject of the contract, if the consideration is not proper, so in that case there may be a dispute, there may be a breakdown of a contract. So either of the party may go to the court and ask for the specific performance. And next is injunction. So injunction may be granted by the court. Injunction is an order of the court to do or not to do. That means if the party wants to perform their part, then in that case court may order to perform the part. If the party are not ready and willing to perform their own part of the duty, then in that case court may order to court may compel to do or perform their duty. So to do or not to do, that kind of order may be compelled by the court through directing the injunction. So these are the remedies available under the law. Remedies for breach of contract. In this particular, remedies available in case of breach of contract are common law remedy, that is damages, equitable remedy. So now we have just discussed about all these remedies. So if we are talking about damages, so damages are nothing but the compensation. And under the equitable remedy, there is specific performance of a contract, injunction. Suppose if party want to rectify their contract and then they are ready to perform their duties, then in that case they can have rectification of a contract. In other case, suppose if party are not ready and the contract is impossible to perform, in that case they can cancel the contract. Then quantum of merit, then restoration, all these are remedies available under the specific performance and which is available for the breach of contract. There are common law remedies. We have seen that where a party sustained loss by reason of breach of contract, he is to be placed in the same situation with respect to damages as if the contract had been performed. So this has been held in the case of Sunli versus Cunard White Star Limited. Remedy on breach of contract. So on breach of contract, the law grants to the other party or the aggrieved party three remedies. First is damages for the loss sustained, second a degree for specific performance, and third an injunction. The law relating to damages are governed by the Contract Act, whereas the law relating to injunction and specific performance are governed by the Specific Relief Act 1963. What is this breach of contract actually? A contract can be said to be breached or broken when either of the parties fails or refuses to perform his obligation or his promise under the contract. Second, it can be said that when a binding agreement is not honored by one or more parties by non-performance of his promise, the agreement can be said to be breached. So in all these cases there are laws which are sustained. So there are rule 1, 2, 3 and 4 under section 73 of Indian Contract Act. So first rule under section 73 clause 1, when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him. So in this case, suppose one party is breaching a contract, in that case other party may have that kind of remedy and he can get a compensation or damages on the loss suffered or injury suffered, then which naturally arose in the usual course of things from such breach. So it should be in a naturally arose status in a usual course. Next is what which the party knew when they made the contract to be likely to result from the breach of contract. Suppose if party knew about the impossibility to perform, or if the terms and the conditions are now not able to perform, in that case they may have this kind of remedy. Party may have the right of compensation upon the breach of a contract. There is very important case, that is Hadley versus Baxendale. In this case, where two parties have made a contract which one of them has broken, the damages which the other party ought to receive in respect of such breach of a contract should be either such as may reasonably and fairly be considered as arising naturally, that is according to usual course of things from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of both the parties at the time they made the contract as the probable result of the breach of it. So this has been held in the case of Hadley versus Baxendale, and this judgment is also applicable in today in India. Second rule under section 73 clause 3, this deals with remoteness of damages. It states such compensation is not to be given for any remote and indirect loss or damage sustained by the reason of the breach. Damages are measured by the loss actually suffered by the party. The loss must naturally arise in the usual course of things from the breach, or it must be such as the parties knew when they made the contract to be likely to result from the breach of it. Therefore, it follows that a party is not liable for a loss too remote, which is not the natural or probable consequence of the breach of the contract. Third is, we will see this Madras Railway Company versus Govinda. In this case, the plaintiff, who was a tailor, delivered a sewing machine and some clothes to the defendant railway company to be sent to a place where he expected to carry on his business in an upcoming festival. Due to mistakes made by the company's employees, the goods were delayed and were not delivered until some days after the festival was over. The plaintiff had not given any notice to the railway company that the goods were required to be delivered within a fixed time for any special purposes. On a suit by the plaintiff to recover a sum of his estimated profits, the court held that the damages claimed were too remote. So here this case is about remoteness of damages. So here party may have that kind of benefit. Then third rule, which is under section 73 of the Indian Contract Act, in estimating the loss or damage arising from a breach of a contract, that means which exists of remedying the inconvenience caused by the non-performance of the contract, must be taken into account. That means if the loss and the damage which is arise under the breach of contract, that needs to be actually count that existence of remedying the inconvenience. What is this? This means that if the inconvenience is caused by the non-performance of the contract, then remedies are available that should be benefited, or that should be given remedy, or the justice should be given to the proper party. Fourth rule, section 73. Damages payable for the breach of a quasi-contract are exactly the same as those payable for any other contract. So, quasi-contract is nothing but it is a contract only, but it is like a contract. It is not a contract, but it is like a contract. So, it should be noted that when no loss arises from the breach of a contract, only nominal damages are awarded. Damages are given by way of restitution and compensation only, and not by way of punishment. So this comes if the damages, if we are talking about, so there are civil remedy and there are criminal remedies. So we are talking about the remedies which are available under the civil law or the civil case. So all this contract law comes under the civil law or the civil case. So here if you are talking about damages or the compensation, that is available under the civil law, and there will not be any kind of punishment. So the aggrieved party can approach to the court and ask for the remedy. So here he can recover the actual loss caused to him as a compensation. Now we'll talk about a decree for specific performance. So this is a decree. If you are talking about a specific relief act, so here I would like to tell you that Indian Contract Act, which defines various concepts regarding the contract, the essential element of a contract, or the formation of a contract, discharge of a contract, or the remedies of a contract. So all these are regarding general contract as well as special contract. But suppose if there is violation of their rights, or suppose there is any breach of a contract, so there is a remedy. That remedy is available under the specific relief act. So specific performance, that may be ordered by the court, or suppose if there is breach, so there may be a injunction or declaration, or the order of specific performance. So whatever the order of the specific performance court will give, that is treated as a degree of specific performance. So according to section 10 of the Specific Relief Act 1963, there are 7 cases when specific performance of a contract may be allowed by the court. First, when there is no standard for ascertaining actual damage. Second, when it is impossible to quantify the actual damage caused by the non-performance of the act agreed to be done, the court may, in its discretion, grant a degree of specific performance of that act. So here, suppose if party at the time of entering into a contract, they were ready and willing to perform the part, whatever the terms and the conditions were fixed under the agreement of the contract. So at that time it was possible, it was likely to be performed by the parties. But after some time, what happened? Party are not willing to perform their part, and it is impossible to perform them those terms and the conditions. So there may be a breach of contract, and due to that breach there may be a damages or loss to the party. So in this case, actual damage is caused due to this non-performance of the contract, that should be measured, that should be calculated, and court may give directions on this point. They may use their discretion and they may grant a remedy of a specific performance. So it is called as a degree of specific performance. So this case is also very important. Duke of Somerset versus Cookson. This case is also applicable in India. Art, painting, old furniture, antiques, etc. have a special value to the contracting party, although such articles may not have much monetary value. For example, an idol which has been passed down from generation to generation of a family has immense value to that family, even if it means nothing to someone else. No amount of damages can compensate for the loss to the members of the family, even if the court makes an attempt to assess the damages payable instead of the idol. Therefore, an order will be passed for specific delivery of that idol, not for damages. Now we'll talk about when monetary compensation would not afford adequate relief. When the act agreed to be done in such that compensation offered in money for its non-performance would not afford adequate relief. However, until the contrary is proved, it is to be presumed that the breach of a contract to transfer immovable property cannot be adequately compensated by payment of money. Then, the breach of a contract to transfer movable property can be so compensated except in the following cases. 1. Where the property is not an ordinary article of a commerce or is of special value or interest to the plaintiff or consists of goods which are not easily obtainable in the market. And second, where the party is held by the defendant as the agent or trustee of the plaintiff. Here, usually, the courts are entitled to presume that in case of breach of a contract to transfer of immovable property, here compensation is not adequate relief, whereas specific performance is adequate relief. So there are certain cases. So the possibility of performing their part, if that is possible in that case, so there may be a specific performance, that kind of relief or the remedy that court can give. Whereas in the case of movable property, compensation is the ordinary relief. So in case of immovable property, specific performance or compensation may not be there and the specific performance will be there. So whereas if we are talking about specific performance, that may be adequate in some cases. Suppose if I am talking about movable property, so compensation is the ordinary relief and specific performance is exceptional. However, it must be noted that these presumptions are rebuttable. So here, suppose if I am talking about immovable property, movable property, so these thing of asking the relief or granting the relief or the remedy of an injunction, declaration, or specific performance that may vary or change according to fact, circumstances to circumstances, place to place, and parties to party. So now we'll talk about suit for enforcement of a contract to execute a mortgage. In a suit for the enforcement of a contract to execute a mortgage or furnish any other security for the repayment of any loan which the borrower is not willing to pay at once, specific performance may be allowed. So here specific performance may be remedy. However, where only part of the loan has been advanced by the lender, he must be willing to advance the full amount of the loan. So he should be ready and willing to perform his own part. So the remedy which is available under the Specific Relief Act 1963, an injunction. An injunction is defined as an order of a competent court which is forbids the commission of a threatened wrong, forbids the continuation of a wrong already begun, or commands the restoration of status quo, that is the former cause of things. Clause 1 and 2 deal with preventive relief, whereas clause 3 deals with an injunction called mandatory injunction, which aims at rectifying rather than preventing the defendant's misconduct. So temporary or interim injunction and permanent or perpetual injunction. There are two types of injunction. So here if we are talking about temporary or interim injunction, these are governed by Order 39 of Civil Procedure Code. Those injunctions that remain in force until a specified period of time, that is 15 days or till the date of the next hearing. Such injunction can be granted at any stage of the suit. What is this permanent or perpetual injunction? So under section 38 to 42 of the Specific Relief Act 1963 are contained in the decree passed by the court after fully hearing the merits of the case. Such an injunction permanently prohibits the defendant from committing an act which would be contrary to the plaintiff's rights. Now we'll see when are perpetual injunctions granted. So here in this case section 38 is very important of Specific Relief Act 1963. So whenever the defendant invades or even threatens to invade the plaintiff's right to enjoyment of property or right to property itself, the court may grant to the plaintiff a perpetual or permanent injunction in the four cases. 1. Where there is no standard for qualifying the actual damages caused or likely to be caused to the plaintiff by the invasion of his rights. Second, where invasion of the rights, plaintiff rights, is such that any compensation in money would be inadequate relief. Third, where the defendant is a trustee of the property for the plaintiff. And fourth, where the injunction is necessary to prevent multiplicity of judicial proceedings. So mandatory injunctions are granted in cases where in order to prevent the non-performance of an obligation. So it is necessary to compel the performance of certain acts which the courts are capable of enforcing. Here we need to understand the importance of mandatory injunction. Section 40 of the Specific Relief Act 1963 states that a plaintiff may claim damages either in addition to or in substitution for suing or filing a case for perpetual or mandatory injunction. And if the court deems fit, it may even grant such damages. Damages cannot be granted unless the plaintiff has claimed damages in the plaint. So plaint is nothing but the case, civil case. In the conclusion, I would like to say there are several remedies available in case of breach of contract, none of which are very simple. One would have to overcome an abundance of challenges and rebuttals to prove a case of breach of a contract. That means what? So the case, each case is differ from party to party, fact to fact, and circumstances to circumstances. And here each and every party needs to prove their own part. They need to tell to the court in a proper manner, then only they will get the proper justice or the remedy under this breach of contract, and they will have that kind of remedies which are available under the Indian Contract Act and Specific Relief Act 1963. So these are my references. I have used these references, and then thank you very much.